Seconds longer so everyone can get in from the chat or the waiting room. All right, I think that is everyone, so we will just jump into it. Good morning. We're going to start with our normal Zoom housekeeping instructions that we do every week. Please stay muted. This is so we can minimize background noise. You can unmute yourself if you have a question or want to clarify something that you've put in the chat, but otherwise, please stay muted. If you're wondering how you mute yourself, there is a Zoom toolbar. It's probably flashing because Chelsea put in a message, our normal welcome message. And this is also where you can find the chat function in this toolbar and where you can submit questions during the Q&A. We expect to have time to answer questions that are submitted into the chat, so feel free to start thinking and putting them in as they come to you. Our general reminder that this is not legal advice, it's general information, so please don't take it as legal advice that is specific to you or your community. That is only information that can be given to you by your association or your personal attorney. And please keep in mind that the chat function during this Zoom is intended for questions and requests of clarification, not legal advice or commentary that you would see on the CAI message board. The CTA is still being challenged. That's the Corporate Transparency Act. It's being challenged by the National CAI, and we still recommend waiting until later in this year to comply. I think that the National CAI is preparing a brief, or they're doing something to challenge the decision that came out of the Alabama court or district court earlier this year. So we're keeping an eye on that, and we'll let you know if we get any updates. Starting June 6th of this year for WUCIOA communities only, there are a number of revisions coming into effect. So if you're a WUCIOA community, you should be aware of them. The revisions are not currently available on the legislative website with the statutes. So this basically you're going to have to look for it, or you can wait until they're updated on the website. Just as a big FYI, statutes for records, notice, and voting that used to match for every association across all the statutes for the last 9 months, those will no longer match. So we will have to changing that, but just keep in mind that those are some of the key changes. There's no Q&A on June 19th or July 3rd, so you can mark your calendars now. And lastly, there is a free DEIB, which is Diversity, Equity, and Inclusion and Belonging webinar for WSCAI members on June 20th. There is going to be a link in the chat if you are interested in attending. Like I said, we will probably have time for questions, so put them in the chat. And with that, we will jump into what we have prepared today. The first one is, we have an owner who says that she is excluded because she does not want to pay for long distance rates, phone rates. Yes, those still exist for the call-in number to Zoom from a 253 area code to a 425 area code. So starting out, the association does not need to offer a free way for a person to participate under the statute. That being said, there are many free options for a person to use to participate virtually or by phone at a meeting that is held on Zoom or not in person. When you create a Zoom meeting, there is a Zoom link that you don't need an account for that you can just attend by clicking the link on your computer. You can download the app and not sign in if you're on a phone. We think it's odd that in today's day and age that someone is paying long distance rate for basically a Tacoma area code to an Everett area code, but that may be the case if the phone plan for the landline is really old or if someone's calling from out of the country. So it is possible. It's also worth noting that according to Pew, as of January 2024, 97% of Americans have a cell phone. So this issue of long distance rates for, I guess, domestic phone calls is going way down. But going back to the issue of whether or not she's being excluded from a virtual or telephonic meeting because she has to pay long distance rates, we don't think she's being excluded because the statute only requires that an owner be able to perceive and comment during the meeting over the phone, not that they not be charged for it. So RCW 6490-445 subsection E, which is WUCIOA, says a meeting of unit owners is not required to be held at a physical location if the meeting is conducted in a way that enables owners in different locations to communicate in real time to the same extent as if they were physically present in the same location, provided that such a means of communication has an option for owners to communicate by telephone. So basically, you just have to give people a way to be heard and to participate. That's all the statute requires. How someone chooses to do that is their own choice. And if you held the meeting in person, there's no requirement that you even offer a call-in or virtual option. So that would be another way to get around it. Ken, do you have anything to add?
Yeah, I think there's something else going on in the community that a person's complaining about the phone. But the statute is fairly clear. You have to be able to provide a phone number in addition to Zoom if you're doing a virtual meeting. But if you can get a quorum without actually doing a virtual meeting, then you can certainly do it in person, and there's no right for the person to call in at all. But at any rate, the next question: when a community switches management companies, what is the industry/ethical standard for how long the handover of documents and monies should take? So there's both a statutory provision now, which was added fairly recently, meaning with the records statutes that were modified in 2023. And then there is going to be a management contract, which may also have some impact on what would be considered ethical and reasonable. The statutes were all revised in 2023 to require that the manager immediately provide all the records. And I'll offer that that's not a particularly reasonable response from the legislature. And then WUCIOA has already been amended. It's one of the changes that take effect next week, to state that electronic records must be provided within 5 business days of termination or a demand by the board, and that all other records written, which is there now, what they're using instead of saying paper, is written is the word they're using. Those must be provided within 10 business days of termination. So I think there's not much question in my mind that if you followed the 5 days for electronic and 10 days for paper, that would be considered reasonable. And that would be true for my interpretation, whether you were a WUCIOA community or not a WUCIOA community. I certainly know that a lot of management companies have, taken longer than that, and sometimes there may be reasons related to the timing of receipt of invoices and being able to process automatic payments, because it may take more than 5 or 10 days to get the accounting reconciled for the previous month. And so, I don't know if this question is coming from a manager wanting to know what they should be trying to prepare for, or from a board member wanting to know what they should expect from the management on termination. Most of the managers that we see transitioning are fairly professional and are providing records in a timely manner to the new management company, but there certainly have been some exceptions. The problem is that there's not a lot of legal authority to push a manager to actually act. So with this new statute, there is a clear guideline, but in order to enforce it, you could still end up having to file a lawsuit against the manager in order to get a court to find that the manager had failed in their obligation. So you're better off trying to find some cooperative way of working with the manager than trying to use the force of the law to move someone forward. Did you have anything you want to add to that, Katie?
Nope. So I will just jump into the next question, which is, if an owner opts out of electronic meetings, how quickly must a board act to accommodate in-person meetings? The short answer is the board doesn't need to accommodate in-person meetings at all, unless your documents specifically say otherwise. So owners don't opt out of electronic meetings, and we don't know if there's maybe some confusion with electronic notice, which owners do opt into, but basically the board decides that meetings are electronic on Zoom or a telephone conference or another platform. And owners can call into that meeting or they can attend on Zoom. And if they don't like either of those options, the board may, but is not required to, set up a separate location for owners to gather and participate in the meeting virtually, even though the rest of the board or the board isn't there. But that's a may. The board doesn't have to offer that option. As I read in response to question number 1, at least for WUCIOA communities, they're not required to be held at a physical location if you give people an opportunity to comment real time and your documents don't say otherwise. For non-WUCIOA communities, the statutes say something similar, which is, at least for example, RCW 6434.332, subsection 2B says that meetings can be held virtually if the process provides all owners an opportunity to hear or perceive the discussion and to comment, which is very similar to what WUCIOA said, though WUCIOA was more specific. But the statutes treat virtual meetings the same as in person. So if you have a meeting over Zoom, and you have a vote, that vote happens basically at the meeting. It's like it's in person, there's just a screen there. There's no distinction between a Zoom meeting versus a physical presence. And a large part of that was in response to like when COVID hit and those statutes changed in response to make virtual meetings more accessible and basically so people could get things done. So if an owner doesn't want to, if they opt out of attending an electronic meeting, that's fine. They just don't attend the meeting. The board does not need to accommodate a person if they don't want to attending a virtual meeting or an electronic meeting. And if an owner demands it, which I think was a question earlier, the board, unless the documents say otherwise, does not need to set up a non-virtual meeting. Ken, do you have anything to add?
Yeah, the feedback we're getting is that associations are getting better attendance and are more likely to meet their quorum with the virtual meeting, even though they may have a clubhouse and people could walk to the clubhouse for meeting. That the Zoom platforms and similar have increased participation. And so I get a little confused when I see questions about trying to force boards back to in-person meetings. But it is possible because there have been some cases and the legislature has provided that if you want to require people to attend in-person meetings, or you want to require that people show up at a meeting to vote, that you can do that. So it's possible to eliminate proxies in your governing documents. It's possible to require in-person meetings to make it more restrictive on who gets to vote. It just is going to make it a lot harder to reach a quorum. The next question is regarding a follow-up to a discussion about attorney-client privilege. What does that imply about email discussions among board members? So the start is that emails between the board members are not covered by attorney-client privilege in any way because they're not a communication with the attorney. Even if they're discussing the legal matter or they're discussing the attorney's advice, that doesn't create a privilege. Okay. And if the emails were requested in discovery and litigation, they would have to be turned over. Okay. This sort of gets to the question about whether or not boards are talking about trying to have discussion about association business via email instead of doing it in an open meeting. And, we've had a lot of discussion over time about boards that want to have closed meetings. They want to have private discussions while they're making decisions or deliberating about issues. And there's no question that the statutes are trying to push for transparency and all discussion to occur in open meetings. And I guess we as an office get confused at the reluctance of boards to comply with the open meeting requirements and to have the discussions in the open meetings. So we think that if you're trying to use any kind of an email discussion between board members, you are going against the legislative intent to have open meetings and the ownership have the ability to observe and hear all the discussion while the board is making decisions. Did you have any comments on that, Katie?
I actually do. I recently had this come up with someone else where they were using not email, but a chat, like web page sort of thing for the board just to talk. And I think it's worth noting that any of those forum chat things, just because they're not emails, I don't think that that gets you around what Ken just talked about, which is basically those discussion boards should still be open if you have an open meeting requirement. They shouldn't be used to get around because they're not technically emails. Okay, next question. Does WUCIOA have anything to say about committees, particularly how much authority they can have? And the answer is yes. RCW 6490 410 subsection 6 says, except for committees appointed by the declarant pursuant to special declarant rights, all committees of the association must be appointed by the board. Committees authorized to exercise any power reserved to the board must include at least 2 board members who have the exclusive voting power for that committee. Committees that are not so composed may not exercise the authority of the board and are advisory only. So to boil that down, committees must be delegated authority by the board to act, and they must have at least 2 board members with exclusive decision-making authority. The board cannot give authority to the committee that it does not have itself. And if there are not more than 2 board members, or there's no authority delegated by the board, then the committee is advisory. So if you only have 1 board member on your committee, it's an advisory committee. Even if, say, the governing documents give that committee authority, you still need the 2 board members with exclusive decision-making authority to be able to make a decision that the board can make. They can advise the whole board to make a decision with only 1 board member, but they can't actually make a decision. Ken, do you have anything to add?
Yeah, we have a number of communities that are trying to use committees to help encourage volunteers to participate in how the community functions. And it's a challenge for them because if they do put them on the committees and then tell them that they don't have any voting authority for the committee, it sort of discourages participation. But if your committee structure is set up so that you're just advising the board, then that is still a good way to encourage the volunteers. And we would usually write into our bylaws that the board can at any time take over any of the functions of a committee, because we have seen committees try to sort of wrest control away from the board because they have been assigned something like architectural control decisions. And I think WUCIOA makes it pretty clear that the ultimate control rests with the elected members of the board, not with appointed committee members, that the community as a whole does not have the power to remove from office. The community as a whole can remove board members, so they do have control over the committees as well.
And there are just two related follow-ups about this that I think would be good to answer now. So the questions are basically how can you have two board members on a committee making a decision if you have to have approval from a majority of the board, or there are 5 members on the board, and how do you balance that math? And I would say, because the board is the one creating the committee, which is done by a majority of the board, and they're delegating that power to the 2 board members, that's how you get around the board rule on decision making and not needing the majority, because that authority has been delegated.
Right. So two examples of committees where this might function is, one would be like an architectural control committee, where the full board doesn't want to review it. So you might have a committee with 2 board members and, I don't know, 2 non-board members, and the committee would review the architectural control requests, and the committee could approve them because the board is delegated authority to approve them, but only the 2 board members could vote. And if the 2 board members are not present, then the committee could not make a decision. They would have to bump it to the full board. Another example might be related to delinquencies. You might want to create a committee with 2 board members to work with your delinquent accounts instead of having to have a full board meeting. That way you could deal with decisions about late notices or assigning a account to an attorney without having to bother the full board. It might allow the committee to make decisions in between board meetings, and might have the treasurer and the president be that committee. So there are legitimate reasons to try and save the full board a lot of busy work by delegating some specific tasks to committees and then letting those committees exercise the authority of the board. Just the charter for the committee has to state what the authority is, or the resolution from the board creating the committee needs to state what the authority is. And then it has to be within the limits set by the legislature. So, for example, even if you had a committee for delinquencies, the statutes were revised so that in order to actually do a foreclosure on a unit in a community, you are required to have a vote of the full board to authorize the foreclosure. And it has to be in the meeting minutes, and it has to be for every foreclosure. You can't have a blanket decision to foreclose any home that's delinquent more than a year. So, have we beat that one to death?
I think so.
Okay. The next question. Do you recommend sending any delinquency or violation notices via priority mail instead of first-class mail? So all 4 of the statutes which govern communities were amended in 2021 and basically stated that we don't care what's in your governing documents, that notice has to be sent by personal delivery, public or private mail, or a delivery service, or if an owner has agreed to it, by electronic transmission. So we wouldn't use priority mail ever, because first-class mail is what's going to get delivered, and first-class mail is what complies with the statute. Valerie, who handles or supervises all the collections in our office, she considers regular first-class mail as the golden standard, because it doesn't require that the owner take any special steps like going to the post office or signing to receive the mail. But it is a statute that overrides all the existing governing documents because of the notwithstanding language in the statute. Okay. What do we recommend? Well, we do recommend regular mail. And if there's some other compelling reason, we might send it certified or priority, or with a return receipt requested. But most of the return receipt requested just get returned to us. The owners don't agree to sign. So if you've got something different in your governing documents, we might say do both, because a lot of people are going to refer to a single document instead of the statute. And then for violation notices, especially if you're trying to get compliance, my standard is do what's most likely to reach the owner and communicate with them. If you know that they're not picking up their first-class mail, then use email as well, and use multiple methods of communication when you can. Meaning if you have an email for them, even though you're required to send it by first-class mail, send them an email in addition, because you're more likely to get a response. Anything to add, Katie?
The only thing I'd add is for delinquency notices, you are required by statute to send them first class mail. So as Ken said, you could send it another method as well, just to make sure they get it. But at a minimum, you have to do first class mail for delinquencies notices specifically. All right, the next one is when governing documents say that dues are payable semi-annually, would adding a second option such as or annually create any kind of clarity with calculating interest charges on delinquencies? So our short answer is probably not, and we actually think it might create less clarity, but you should check with your association attorney about this specifically. If you want to allow owners to pay annually and your governing documents state that payment is annually, you would need, or semi-annually, you would need to amend your governing documents to also allow for whatever the other option is. So if it says semi-annually and you want to make it annually, you have to amend it to make it both and vice versa, which just from the get-go seems like a lot of work. It's worth noting that there's probably like a formula or an Excel program that you can use to that can calculate the interest on delinquencies for you. So changing the semi-annually payment to annually could be clarified basically by a computer doing the math for you. We also think that there's a lot of ambiguity if you have two options for when payments are due, because how do you start counting when it's delinquent? If you tell people that it's due annually or semi-annually, they're going to be delinquent if they don't pay the second amount rather than the first amount, because they have two options. And so with the two options, the default would be interpreting it in the most favorable to the owner, which would be, I guess, the second payment amount. And so it makes it really hard to be precise in knowing when amounts are due, and it would make it hard to know when you're getting your income stream from each payment. So all that to say, I think you should talk to your association attorney about ways to clarify calculating interest on delinquencies, because changing and having two deadlines for when payments are due seems more complicated. Ken, do you have anything to add?
I guess I'd phrase it as you can ask the owners to pay annually and in a single lump sum up front. But if the document says semi-annually, that's what you would have to use for enforcement of the payments. And so you couldn't assess interest on the annual payment. You'd have to assess it based on the semi-annual. Next question. The passing of Senate Bill 5796 is confusing wording. It takes effect on June 6th, but doesn't repeal the other acts until January 1 of 2028. So question is it business as usual until January 1 of 2028? The Senate report says that WUCIOA applies to common interest communities beginning that date. A community is not governed by a WUCIOA may continue to be governed by other applicable statutes. Is that the final answer? I'll say yes with a caveat. And the yes with the caveat is because there were a number of changes made to WUCIOA that take effect this year. And when this was originally going through the legislature, WUCIOA was going to take effect and impact all communities much earlier than 2028. So when the records provision of WUCIOA was amended, they did not amend the other three statutes. When the meeting and voting provisions were amended, they did not amend the other statutes. But I think that the intention of the legislature was that those changes actually apply. So, for example, the requirement that voting for elections and for amendments be done by secret ballot, which found its way into the WUCIOA statute effective next week. I think that that was actually the intention of the legislature to have voting records protected for all communities, but that's not how the statute reads right now. So it's certainly true that if you're not a WUCIOA community now, that the original statute as it's written applies. But you do have this problem where the courts look at what the legislative intent is, not necessarily what the exact wording of the statute is. And so if there's any ambiguity in an existing statute, the court might look to the WUCIOA language as indicating what the legislature intended when they had written the previous one. And, you know, I used to use the records documents or the records statute as my example, because in the old versions before 2023, there was a single sentence that talked about records available to the owners, and WUCIOA had 2 pages. And so I would say, look, the legislature could not have intended that every record of the association be available, because you're certainly not going to provide things like unlisted phone numbers and privileged attorney-client communications. So I'm going to look to the more precise language of WUCIOA to help me understand the legislative intent. So I guess the shortest answer is yes, you use the written statute which applies to your community up until 2028. You can certainly adopt WUCIOA earlier, and we have a number of communities that are doing that. We're actually recommending that any association that is revising their documents go ahead and adopt WUCIOA now. But keep in mind that if it is something that the legislature has actively been manipulating, like the records, voting, meetings, that those are probably guides on how you should handle issues, even for older communities. And things like the holding the meetings or how you vote are good examples that I might cite for that. Anything you want to add, Katie?
Nope. So the next question is, I read that Washington law addresses restating bylaws, but not CC&Rs. Can CC&Rs be restated, and what is the process? Is the restatement considered an amendment? So yes, CC&Rs or declarations, depending on what you call it, are commonly restated either to reflect best practices, changes in statute, or just to condense a bunch of other amendments, usually parking amendments. So it is an amendment, and it basically creates a single document to replace all prior amendments and do a bunch of stuff at the same time, like adding new provisions. And the process is the same as any amendment. The board approves the draft of the restatement, and the actual text is sent to the owners. And the owners review it and vote on it, either at a meeting or by absentee ballot, or same normal voting process. And once the owners approve the amendment in the same way as any other amendment, so whatever your documents require for amendment 67% or whatever it may be, it is signed and notarized by the board president and the secretary, and then it is sent to be recorded with the county. You can restate your bylaws at the same time. So remember, the bylaws are what address the governance of the association, and your CC&Rs or your declaration address the property and the obligations and rights and restrictions. So you can do both documents at the same time, and your bylaws will not need to be recorded unless they already were recorded. But to be effective, your CC&R or your declaration restatement does need to be recorded. Ken, anything to add?
No, I'm good. Next question. After we amend our declaration to adopt WUCIOA, what is involved in restating our CC&Rs and bylaws? It seems like that would be a big task. I understand we have to do it, but we'd rather not have two sets of documents for owners to refer to. Also, if we adopt WUCIOA, do we have to abandon our 6-unit rental cap and the 3-year rental limit? Okay, so you can certainly adopt WUCIOA without restating your documents. It's just any of the existing language which conflicts with WUCIOA will not be enforceable. There is a provision in WUCIOA that allows the board alone, without a vote of the membership, to amend the declaration to eliminate conflicts in the documents from the statute. So, for example, if the old act requires a 60% approval for an amendment, but WUCIOA requires 67%, the board could amend the declaration to change that percentage, and they would not require a vote of the membership. You're required to give notice to the membership that the board's considering doing it. You're required to get 2/3 of the board members to approve the change, but then it's done. You don't have to do much more. If what you want to do is make amendments which are incorporating optional portions of WUCIOA, like the ability to assess insurance deductibles or the ability to make owners pay for damage that's caused because they don't follow maintenance standards that are in the governing documents, then you will have to do a regular amendment and get the ownership to vote. And so it is something that you're going to probably need an attorney to help you with. It's something that our office does on a regular basis with a lot of different communities. There's at least a dozen other law firms that do these amendments and restatements as well. But you don't need to modify the document. It just makes it easier to follow if you're not familiar with all of the conflicts that may be within your document and the new statute. As regards to a rental cap that's existing, adopting WUCIOA does not change the rights and obligations of the owners in most cases. If you've got a rental cap now, you would have a rental cap under WUCIOA. If you have maintenance obligations for the unit and limited common elements, they are no different once you adopt WUCIOA. If you've got restrictions on use, they are not going to be different under WUCIOA. So you don't have to worry about losing rights and obligations as owners by the adoption of WUCIOA. In most cases, if you've lost a right or been mandated to do something, it's been done for all community statutes, not just WUCIOA. So the obligations to allow solar panels or heat pumps or childcare facilities or adult family homes, all of those are in the statutes now. They're not going to change at all when you go to WUCIOA. So, anything else you want to add on that, Katie?
Nope. So the next question we got was very detailed, but we have just condensed it to what is applicable to a larger audience, which is basically there are 4 board members, all except one of the 4 board members agree on how to move forward with a certain action. And the question is, how can we move forward on a decision when we don't have all board members in agreement? And without looking at the governing documents for this community, we can't answer specifically, but we can say generally how board approval works. And unless your documents state otherwise, you do not need unanimous consent of the board to take an action. Typically, if a decision is to be made at a board meeting, you only need a majority of the board members present when you have a quorum. And if you're looking for that statute for at least WUCIOA communities, it's 6490-450 subsection 2, which is where it says if a quorum is present when a vote is taken, the affirmative vote of the majority of the board members present is the act of the board, unless a greater vote is required by the organizational documents. And sometimes your documents may say that any decision by the board must be a majority of the total board. So 3 out of 5, if that's how many you have. But basically, it depends what your documents are. The only distinction is if you're trying to make a decision over email and you are a non-WUCIOA community, then that decision of the board does have to be unanimous. Only if it's over email. If you're a WUCIOA community, then you can't make anything other than ministerial decisions over email, and your decisions have to take place at a meeting. That doesn't mean that they have to be unanimous unless it's required by the governing documents, but it just means it has to be at a meeting. So if you can't get all members to agree on something over email, just hold the vote at a meeting where you probably are not required to have unanimous consent. Ken, anything to add?
No, I'm good on that. So last question we had submitted in advance. If a notice of the association's annual budget meeting falls short of the 14-day rule and moves forward regardless, is the ratification legal? Or does the current budget remain in place until proper notice is given and a new vote? So first we'll offer that we'd have to see all the specifics for your community to be able to give legal advice on it. But as a general rule, under the facts presented, we would say, no, it would not comply with the requirements of statute, and the prior budget would remain in place. And that's because the statute specifically says, and this is 6490-525, that if the proposed budget is rejected or the required notice is not given, the periodic budget last ratified continues until the unit owners ratify a subsequent budget. And so if you only provided 10 days notice for a budget ratification meeting and held the meeting, then we would, without more facts, tell you that you should go back and hold another meeting and ratify it properly if you were going to look to enforce the collections of the new amount through our office. So anything you want to add, Katie?
Nope. And so I will just start reading some questions from the chat. I don't know if any were sent to Chelsea individually. These were just the general ones. So the first one is, with a management company change, should the outgoing management company provide closing financial reports, reconciliations, etc.? And I would say you should look at your management contract to see what happens when there is a transition between management companies. Usually, at least the contracts I've looked at will say what the, I guess, old management company, what their obligations are, what they will provide, and not talking about timing, but how all of that will work and how they will deal with the transition. Ken, do you want to add anything?
Well, I think that the old management company is going to need to reconcile, and that probably means providing the closing financials that you're describing. Most management companies are not going to provide the electronic database of all of the transactions, checks deposited, checks issued, etc., in order to allow the new management company's software to pick up and reconcile all the previous accounting records. So I think that most of the management contracts I've seen do anticipate giving a closing statement. I'm trying to remember if the statute requires that an audit be performed. Certainly an audit could be performed, a transition audit, similar to what you could do when the declarant gives up control of an association. And that would be a way of reconciling the accounts for the old management company. It would be an expensive way of reconciling the accounts, but it's the only way you'd have the certainty that everything had been handled properly. And that would be a decision the board would have to make about, you know, the cost and benefit of having that certainty. So I'd sort of look to the management contract first, look to what seems fair and reasonable. I think that the management company should be providing closing statements, yes.
All right, so the next question, I believe, came in when we were talking about discussions of the board over email and how we were saying that you can't get around an open meeting requirement by having a discussion over email. And the question is, how does that square with closed meetings? And I would say that you can have discussion over email if you don't have an open meeting requirement, but you're not being very transparent. And you will be subject to open meeting requirements in 3.5 years. So it would probably be a good idea to get out of the habit of having a lot of discussion over email now.
Well, I guess I'll add, it depends how we're defining closed meetings. What Katie just described would be for condominium associations that do not have in their documents open meeting requirements. If when you say closed meeting, you are thinking of executive sessions, I would offer that there should never be any emails that are discussing what would be discussed in an executive session, because that's supposed to not have meeting minutes or other records. And the use of executive sessions are limited to very specific topics. You can't just decide you're going to discuss something in a closed meeting by calling it an executive session. So, yeah, I get a lot of questions which seem to me like ways to work your, you know, for the board to discuss things without disclosing it to the membership. And my response is usually being open and transparent is better.
Yes. So the next question is, what happens when no one wants to be on the board? Ken,
Well,
I'll let you take
yeah,
this
we
one.
get this question a lot, and there's this theory that you could appoint a receiver to manage the association. The problem is that to get a receiver requires a court to appoint the receiver, and to get that requires somebody to sue the association and serve every one of the owners. So in a practical sense, you're not ever going to get a receiver. I've had 2 situations where receivers were appointed. One was where the developer owned most of the units and went bankrupt, and the court appointed a receiver to manage all of the units through the sale of the developer's assets. And there's actually one down in Tacoma right now where there's a receiver. And I assume also, again, because the developer went bankrupt. So the answer is that probably whoever was the last board member standing is still a board member, even if they say they've resigned. They would still have the legal authority to appoint a replacement. They would still have the legal authority to sign the tax returns or whatever documents need to be done. And again, this is general advice as opposed to something specific. I'd need to see your your individual documents to know for sure. But there was a court case in New York State where the court just determined that the last board member could not resign, prohibited them from resigning because they were going to leave the corporation with no representative. In a practical sense, if no one wants to serve, you need to start looking at spending more money in order to make it more attractive to serve. If you hire more managers, more accountants, more consultants, more attorneys to do the work in evaluating all the decisions and giving advice to the board, you will substantially reduce the amount of effort required by the board members. You will also increase the cost to the community of doing everything. Okay. And it's okay to have a community that's willing to spend money instead of their time in order to make the community function. We certainly have some communities where they've gotten the time commitment for the board down to a couple hours a month. They have a 1-hour board meeting, and the board members would have to review the material presented to them in advance of the board meeting so that they can make decisions. But they have a lot of information prepared for them in advance, and they get recommendations from their managers, accountants, attorneys, consultants on what the board should do. And so it becomes much easier for the board members to make decisions. I don't know if you want to add anything to that, Katie.
The only thing I'd add is it's a lot less work for maybe 3 board members to make these decisions than if you're that one last board member standing. So if you likely have the authority to appoint people to fill those positions, that's a good way of at least reducing everyone on the board's workload, because then it's not just saddled on one person's shoulders. Okay, next question is, for minutes of regular board meetings, should names of owners in attendance be included or not? I think if you have to give owners an opportunity to speak and comment, you could reflect that in the minutes, like who spoke, but I don't think it's required. I was thinking it said, do the board members in attendance have to be reflected in the meeting minutes, which I would say yes, but then I read it again and it's a different question. Ken, do you have a different opinion?
I don't think there's a requirement to list the owners. I would say frequently I do see that the minutes will list owners in attendance or visitors in addition. Sometimes the meeting minutes will list the names of the managers in attendance. And if there are guests like an attorney or an engineer, they will list those people as attendees also. But I'm not aware of any statute or even Robert's Rules of Order that would require that the the owners in attendance be listed.
All right. Next one is, for 3 years, we have not had a quorum at the annual meeting. No one wants to be on the board either. What records should we have showing the annual board meetings were held, but not enough people attended? I believe that should be reflected in the annual meeting minutes, basically that no quorum was reached. But then I don't know how you approve the minutes. So Ken, have you experienced this?
Well, I guess from my perspective, you're going to have a record of the notice going out. That would be an official record. And I think I would probably have something, it may not be called meeting minutes because it's not going to be officially meeting minutes, but just a document of some sort that would reflect that the meeting date came and there was not a quorum achieved. And you can state whether or not the board went ahead and presented information to the people who showed up, or you can just state that no business was conducted. If you were to have a ratification of a budget, I would want to make sure that there was a document that reflected that no quorum was achieved, and as a result, the budget was automatically ratified. And I'd want the board secretary to just make that memo and save it with the other association records.
I would say also, because I know no one wants to be on the board, so that assumes there's probably not enough to get an election going. If you're appointing anyone to the board to fill a remainder of a term, that should probably be included on either board meeting minutes or whatever document you are tracking what Ken just said. All right, last question in the chat, which is the bylaws state that that meetings of the members of the association shall be held at a suitable place as may be convenient to the membership. In the new meeting section of RCW 6434, meetings of owners may be conducted by telephonic, video, or other conferencing processes. Can this be included to mean conferencing processes can be a suitable substituted for place? Basically, can you use the place of the virtual space as a suitable place for a meeting? And I would say yes.
I would say yes also.
Okay, I lied. There's actually one more question. I heard that WUCIOA requires all owners to receive the same information in advance of regular board meetings as the board members receive, except for financials with board-only information like delinquencies. That can be a lot of pages. Is that really required?
I would say that's a false statement. The statute says that you have to make the information available to owners, which is different than sending it to all the owners. So if there's a 50-page board packet, which contains copies of all the invoices or reports, etc., and you're sending it out to the 3 or 5 board members in advance of the meeting, and an owner requests that information, I would say you have to give it to the owner. But you do not have to mail it to all of the owners. You do not have to put it on a website for all the owners to see. I think those are things you could do if you wanted to, but the statute does not require that you give all of the information provided to the board to every owner in advance of the meeting.
Ken, I think Chelsea had a question come directly to her, and we have 2 minutes, so.
All right. My association's declaration was written in 1991. A board member has stated that we legally cannot hold executive sessions, as according to him, there is a conflict between the declaration and bylaws. The board member also stated that due to the age of our declaration, there is no RCW that applies to our association with respect to holding executive sessions. Can you advise which RCW the association would look to support their legally holding executive sessions?
Well, that's a lot of very specifics, which I don't think we can address on this forum. I would offer that there is always a community association statute which applies to your community, because if you're not formed under the condominium statutes, the Homeowner Association Act has basically wrapped up every other form of community association except cooperatives. So sure, it was formed before the Homeowner Association Act was adopted in 1995, but the legislature adopted the HOA Act to encompass every existing HOA. It didn't matter if you were formed in the 1930s or the 1990s. I would be really surprised to see something prohibit executive sessions, because I think you would have the ability to do some of those just based on the attorney-client privilege. But I would have to see it. To me, it sounds not credible that an association could not hold executive sessions based on how the statutes are written. But that sounds like they'd need legal advice.
Yes, and with that, we are at 11 o'clock. So thank you all for attending today, and we will see you next week.